Welcome to Requirements for a Valid Texas Will, or as I like to call it, the least you have to do to get the job done. My name is Robert Jewett. I created these videos because I love the law and I love to teach. And yes, I really am a licensed attorney in the state of Texas. Before we get to the good stuff, we need to cover a few formalities. First, this information is for educational purposes only. I am not your attorney. And this video and the information in this video is not intended to create an attorney-client relationship. If you choose to seek me out, I'll be happy to discuss your case, but I'm not promising to take your case. And finally, this information applies only to Texas. If you live outside of Texas, your laws might be a little different, or they might be a lot different. I don't know, because I'm only licensed to practice in Texas. So that's where we're going to focus our conversation today. We're going to talk about the requirements for the will, and in that sense, what we mean is the very minimum amount that we can get away with and still have a valid Texas will. Now, those requirements come in two flavors. We have requirements that concern the testator, that's the person creating the will, and those are talked about in Texas Estates Code section 251.001. And we're also going to look at the requirements of the document, that is what the will must say or what it has to contain, and those are dealt with in Estates Code section 251.051. So let's talk about the requirements for the testator. That's you, if you are the person creating the will. Now, the first requirement is that you must have legal capacity to create a will. And to have legal capacity, one of three requirements has to be met. You must be 18 years of age, or at least 18 rather. You must be married or have been married, or you must be a member of the armed forces. Now, you might be wondering how you could be in the second or third group if you're not also over the age of 18. You have to understand many of the rules in the Texas Estates Code were created over 100 years ago, at a time when you could have been married under the age of 18, and you still could be married under the age of 18 if you meet certain requirements, but it's certainly not as common as it might have been back in the day. There was also a time when the armed forces were not, well, shall we say, as stringent about accepting people under the age of 18. So, for example, at the beginning of World War I and World War II, many young men joined the armed services because they felt called to do so. And allowing those young people to create a will is a pretty smart thing to do considering they were about to go into harm's way. Now, the second requirement is mental capacity, and the phrase used is to be of sound mind. Now, if you don't immediately hear the voices of your family and friends joking about being of sound mind, well, you may need some new friends. After all, what does sound mind mean anyway? Well, as it turns out, sound mind has a fairly specific legal meaning. First, it means that you have the ability to understand the nature and composition of your estate. That is, what you own. It doesn't mean that, say, for example, if you own stock in Google, that you understand how Google works. It just means that you understand that you own stock. If you own a home, you need to understand that you have a home and be able to recognize it. Or if you have money, you need to understand about how much you have, not to the last cent, but you need to understand it belongs to you and it doesn't belong to somebody else. Now, the second kind of component of mental capacity is the ability to understand what's called the natural objects of your bounty. That is, you need to understand or recognize family members. People that could be your spouse, could be children or grandchildren, but it's the people who would naturally benefit from the familial relationship. Now, you've probably seen or heard stories about where this requirement was not met. where elderly folks may have left their entire estate to a caregiver who took advantage of them, or to a romantic partner who showed up for a very brief amount of time in someone's life, maybe just long enough to get a will executed that left everything to the new love interest. And finally, you have to understand and intend to make a disposition of property at death. Now, this is not a current disposition. A current disposition is an immediate gift. The distinction is, if I make a gift, you get it right now, not when I die. What we're talking about is a disposition somewhere down the road. And hopefully for me, it's a long way down the road. So now we're going to talk about the requirements of the document. That is the will itself. And what does it have to say? And what does it have to contain? The first requirement is that it must be in writing. Texas does not allow audio or video recordings. So if you've seen movies like Brewster's Millions, where the will is a video playback of the person talking and saying how they want their estate to be distributed, well, that's not a valid will in Texas. If I go on the radio and I say to the world, I intend for my entire estate to go to save the whales, that's not a valid will because it's not in writing, even though thousands of people may have heard me say it. The will can be typed or handwritten. It doesn't matter if it's on the back of a napkin or carved into the block of cement, but it has to be in writing. It must also be signed. Now, there are certain situations where someone could sign for the testator. If, for example, let's say the person had a medical disability, such as being paralyzed or something. But those are exceptions we're not going to talk about here. There's a lot of rules in that situation, and you're best to just go straight to an attorney if that's what you're dealing with. Now, other requirements are that the will must be attested by 2 credible witnesses. So who's credible? Well, generally, the witnesses must be over the age of 14, and they cannot be someone who receives property under the will. So if you are leaving everything to your spouse cannot be a witness to the will. But wait, there's an exception. Under the Estates Code, Section 251.052, if the will is entirely in the testator's handwriting, no witnesses are necessary. And it's this exception that allows us to create what I call a minimum viable will. That is, the very least you can do and still avoid intestacy. Now you may be wondering, what happens if the will is not entirely in the testator's handwriting? Well, in that case, the court will cover up everything that's typed and look only at the part that is handwritten. If those portions meet the requirements and dispose of the testator's property, then you have a valid will. Now, also remember, we're talking about the very least amount required to avoid intestacy. If you have a will that's been created by an attorney, or have seen somebody's will created by an attorney, it probably doesn't much resemble what I've been describing here. If you look, the will should have all the stuff we've discussed, but it probably has a lot of other stuff as well. Now, don't get me wrong, that other stuff is important. I'm not saying it isn't. But what we're talking about here is the least you can do in Texas to avoid intestacy. So at this point, you might be saying to yourself, well, that's great, Robert, but why do I care? So what it means is that assuming a person has both the legal and mental capacity to create a will, then you can handwrite a will without an attorney or any witnesses. You don't need anybody else. While you're sitting here watching the video, you can take out a sheet of paper and something to write with and create a will if you don't already have one. Most people put it off because they think it's inconvenient. Well, you don't have to go downtown and you don't have to do any heavy lifting. You just need to take a few minutes to write out your wishes. And if you've seen my video on intestacy, or as I call it, the zombie apocalypse, you should at this point understand how important it is to have a will. So let's be clear once again. What I am describing is not going to be the best will for you. It's the least you can do to avoid putting your family through intestacy. You should still see an attorney, but at least your family will not be subjected to the zombie apocalypse. So what now? Well, I have a follow-on video called Creating a Minimum Viable Will that will walk you through the process and show you actual examples. If you don't have a will, I encourage you to watch that and, if appropriate, create yourself a handwritten will. The next thing is you should schedule an appointment with an attorney. Remember, a minimum viable will is not going to be the best will. An attorney can help guide you through creating the best will for your particular situation. A minimum viable will just gets your family past the intestacy problem. There's a load of other problems that could happen, and to understand those, you need to see an attorney. So until next time, this is Attorney Robert Jewett reminding you that the better you plan, the better you'll sleep.